Hello everyone, welcome back to my ACCA Law revision series. I'm CA Tanya Kakkad, and in this final lecture of Chapter 1 Part A, we are wrapping up the last set of concepts that students usually find scattered and confusing, that is statutory interpretation and a quick but complete breakdown of Sharia law for ACCA exams. By the end of this session, you will have all the foundations logged in. So, when we move into the next chapters, everything starts falling into place instead of feeling like an isolated rules or concepts. So, let's get started. In our last lecture, we discussed about lawmaking in UK and how it has two branches. One is legislation and the other is delegated legislation, wherein in case of legislation, all the important laws are made here and created by parliament. The purpose is to make new laws such as taxation, to consolidate laws and so on. And in case of delegated legislation has further five branches which subdivides into statutory instruments where laws are made in detail, then order in council where in case of national emergencies laws are made, then professional regulations where laws are made for set of professionals, then courtroom laws, that is court rules, where laws are made that applied on courtrooms, and then bylaws wherein laws are made that applied or are there locally. Then we discussed UK judiciary and basically hierarchy of courts in UK, wherein we discussed that it has two branches. The very first is UK Supreme Court. However, when it goes further down, it is subdivided into two branches, that is civil division and criminal division. Civil division, basically it starts with county courts, then it goes to high courts, where high courts have three subdivisions: family division, Queen's Bench, and Chancery. Then it goes up to Court of Appeal and then Supreme Court. And in case of criminal, it starts with Magistrate Court, then goes up to Crown Courts, then Court of Appeal, and then UK Supreme Court. Then we discussed about three track systems, where small track, fast track, and multi track, wherein small tracks is disputes below £10,000, fast track is dispute between 10,000 to 25,000 pounds and should be completed in one day, and multi track where above £25,000 or complex case laws. And majorly these are handled by county courts, and if it is very complex, it is handled by high court. Then we discussed about European Court human rights, where even if Supreme Court is the last place where you can go for appeal and whatever decisions are made are final. However, if issue pertains to the human rights or as per human rights falls under Human Rights Act 1998, you can go to European Court of Human Rights and file a case even after, but however, after exhausting all the UK court options. However, all the decisions passed by this court is final. And then we discussed about JPC, wherein a Commonwealth nations crown discrepancies and UK overseas territories. This is a final appellant court. For these people, they deal with both criminal and civil appeals. You can go here even after you have went first UK Supreme Court, and they exist in the same building as UK Supreme Court. Whatever rulings they pass are final. Then we discussed about doctrine of judicial precedent. Whatever decision was made previously, you follow the same. And there are five rules that you need to follow if you are following judicial precedent. The first one was it should be based on law, must come from a superior court, material facts must match. It can be overruled by a higher court, and Supreme Court can overrule itself. All right. In today's lecture, let's get started with statutory interpretation. This will be the most interesting chapter for all of you because here we are going to discuss case scenarios. So, statutory interpretation. Let's first discuss what do you mean by statutory interpretation. It is a process where judges interpret ambiguous words and phrases. So, see, many a times laws are made in such a form that a few words are left ambiguous, or ambiguous meanings are not very clear, and judges are required or expected to interpret law, or that meaning to understand the meaning of these laws, to understand the ambiguity, and that is called as statutory interpretation. Interpretation meaning you are understanding or making the third person understand, you're interpreting the law, the statute. All right. So if any such instance happens, and if judge finds out that the law is ambiguity, there is an ambiguity in the law, they have to interpret it. But how will they interpret it? So there are a few rules that they can follow while interpreting the law. The very first rule is mischief rule, and this would be very interesting. There would be some mischief in this, correct? No, it does not mean what it says. It does not mean doing mischief. It basically means it is named as, or it is termed as mischief rule. However, it means that it interprets statute in such a way which provides a remedy to any mischief. The case law is Goris versus Scott, wherein, so this case law, I'll give you a brief about it as we are into a revision series. I'll just give you a brief about all the case laws, wherein Boris gave his sheep to Scott, and the rules that were there, that were pertaining, were whenever you have a sheep, you are supposed to keep sheeps into pens, basically into cages, and you cannot leave sheeps, eh, like just like that roaming around, to avoid spreading of diseases caused by sheep. So the actual purpose of creating the law of keeping sheep into pens was to make sure that these diseases are not spread because of sheep. In our case, Boris handed over his sheep to Scott, and Scott was supposed to take that sheep in a shipment, in like on a cruise or something, and deliver that sheep to a particular place. However, Scott had kept sheep into pens, but he opened the pen to bath, to bathe each and every animal in that particular area. And while doing that, by mistakenly, the sheep went into the ocean, and Scott lost the sheep. All right. And Goris, on the basis of this rule, filed a case that sheep were supposed to be kept in pens, and Scott did not follow the rule. So he breached the rule, and hence he should be, liable, or he committed, or he did not follow rules and regulations, or so on. He did a tort, he did a civil wrong. However, judges followed mischief rule, and they said the interpretation was to make sure that diseases does not spread. The interpretation was not that to make sure that your sheep is not lost. All right. So this rule or that law does not apply to your case, because the rule was made to make sure that diseases are not spreading, and Scott did not do that. All right, he just lost your sheep, so you cannot apply that particular rule. Of course, there will be other rules and regulations that they can apply on each other and find a conclusion. All I'm saying is mischief rule means whenever there is a mischief, you look at the rule and you find a remedy for that mischief. The second one is purposive rule. What do you mean by purposive rule? It is a modern approach wherein court passes a judgment based on interpretation of what was the interpretation of parliament while passing the statute. That is Gardiner versus this. What do you mean by purposive rule? When whenever this, well, let's say we are talking about a law wherein, let's say, for example, hypothetically, we are saying that you are supposed to store a film in the premises. All right. And while making this rule, the parliament, when the parliament was making this rule or passing this statute, Their interpretation was, their actual meaning was to make sure that the film is safe in the premises. All right. So when you're applying this, let's say, for example, a shooting is going on in a cave. Okay. So you can or you should store that film in the premises itself, in the cave itself. Premises need not to be an office where there are cabins or so. The motive of the rule was, the actual interpretation of the rule was to keep the film safe. That means inside the cave would also work. So that is the simple meaning of purposive rule, where you apply a modern approach, and while passing a judgment, judges actually sees what was the actual statutory meaning that parliament wanted to implement while passing that particular regulation. The third one is Ejusdem generis. Repeat after me: Ejusdem generis. What do you mean by this? It says that general words follow a class of specific words. It says that general words follow a class of specific words. What do you mean by that? Let's say a law says that you are supposed to store XYZ materials. Sorry. All right. So you're supposed to store this XYZ material only in rooms, cabin, or let's say office, and other places. So, what does this mean? That you can store this XYZ material only in room, cabin, office, and when you're saying other places, it follows general words follows class of specific words, meaning it follows the class of words that were used before this general words. Basically, these specific words that were used before giving out a general word, this general word, that means other places, will follow the nature of the class of specific words. In our example, room, cabin, office, etc., these places are indoor. So any place which is indoor will fall in other places. All right. So you cannot store XYZ material outdoor. You're supposed to store it indoor. All right. So basically, we are interpreting it because this other word, other places word is creating an ambiguity, is not a clear version or is not a clear word. So if you want to find a clear word, you can follow Ejusdem generis rule, and that means that you will look at the previous word to interpret the other places word. Expressio Unius rule. What do you mean by Expressio Unius? It is basically that it has an established list which is covered by its provisions. Items that are not listed here are expressly excluded. If anything is listed in that list, this rule will apply. Anything which has not been listed will be explicitly excluded. Let's say if any law was made, and specifically a few, let's say a law was made on medical terms, and specifically a few diseases like cancer, diabetes, or any particular disease, let's say hepatitis B or so, only these diseases will follow this particular XYZ rule that has been made. Then judge will apply Expressio Unius rule, wherein if your case comes and it falls under these diseases, this rule will apply. If it does not fall, that means that law explicitly wanted to exclude all other diseases, and hence it will not apply on any other disease. Last two rules. The first one is literal rule, which means that one must be given their normal dictionary meanings, meaning the whatever said whatever is said in law, you are supposed to give that dictionary meaning to it. The case law is Fisher versus Bell, wherein the shopkeeper, Mr. Bell, he just displayed a knife, okay? And legally selling knives were illegal in that particular region or in that particular territory. However, he had just displayed the knife. Now, Fisher came and said or filed a case that he was selling knives. However, it was interpreted in literal rule that the knife was just displayed and there was no price tag below the knife, meaning it was an invitation to offer and not an offer. What do you mean by this, ma'am? We will discuss that in our upcoming chapters when we are discussing contracts and everything. We will discuss that offer and invitation to offer and everything while making a contract. But just understand this right now, that the knife was displayed. He never said that come, he never, the Bell, Mr. Bell never said that, people please come and buy the knife, or he was not showing any intention to sell the knife. He was not selling it. It was just a display. And rule says that you cannot sell knife. It is illegal to sell a knife. All right. So literal rule will be applied here, and the outcome came that it was not an offer, it was an invitation to offer. If you are going and asking that at what price will you sell this knife, and then he is selling a knife, then that is an altogether different picture. The last one is golden rule. It modifies the meaning to avoid absurdity. What do you mean by that? What do you mean by that? Let's take an example of Adler versus George, wherein Adler is a person who obstructed a member of armed force. Now, as per rules and regulations, you cannot obstruct a member of armed force in vicinity. Vicinity meaning in an area nearby the armed force. Let's say there is a camp of armed forces, an area nearby the camp, you cannot obstruct a member of armed force. However, Alder obstructed a member of armed force inside the vicinity and said that as per rules, you cannot obstruct them at, you know, in vicinity, like around vicinity meaning around that camp. But I have obstructed the armed force in camp. Your words were in vicinity, meaning outside or around camp, but I have obstructed in camp. So this uh, law would not apply. However, judges can apply golden rule and say that they have modified the meaning to avoid absurdity. Basically, the actual point was that if there is a person of armed force, there is a person of army, you cannot do anything to that person, be it around the area or be it in the campus, be it anywhere, you cannot do that. So judges can apply golden rule and modify the meaning to avoid absurdity. Are these rules clear? I have given you guys a very clear example in a very simple layman wordings example so that you understand each and every topic in proper meaning or in detail. Now, let's discuss that there are a few presumptions which generally apply unless statute states otherwise. What do you mean by presumptions? Presumptions meaning these are a few, you can say, an unsaid rules that applies when you are making a law or when you are reading laws or any statute or so, until and unless your law itself says otherwise. What are those presumptions? Legislation limited to UK territory and not applied internationally. Meaning, being any rules and regulations made are limited to UK and does not apply to India, China, or so on. It is limited to just UK and does not apply internationally. These are like obvious rules. I mean, ma'am, obviously, if law is made in India, why will it apply to UK and vice versa? However, it is stated The second one states that statute does not bind crown, government, and court are above law. Basically, if there is any rule that says that you're not supposed to walk left on the left side of the road, just example, it is hypothetical. It says that you're not supposed to walk on the left side of the road. However, it does not bind or it does not apply to government or court. These are above law in UK. Statutes should not conflict with international laws. If your law says, let's say, if your law says that you're not supposed to walk on the left side of the road, however, international law says that you can walk on the left side of the road, and a person who does not belong to UK is walking on the left side of the road, your law cannot conflict the international law. No retrospective effect until and unless stated. Okay, so it is like if any law is made. Okay, so let's say if I am coming today, the parliament is coming today and making a law that people cannot walk on the left side of the law of the road. This law has a prospective effect and not a retrospective effect, meaning being from today and going forward from today, people cannot walk on the left side. However, people who were in past walking on the left side of the road were fine. This law does not apply from the past. It applies from today and in future, meaning there is no retrospective effect. Statute does not alter common law. Parliament has no intention to change existing law. We discussed this in common law as well, that any rules and regulations made does not alter the current ongoing law. And statute does not remove court jurisdiction. Statute does not want that people do not come to court. Statute will basically rules and regulations are not made in such a way so that people don't come to court of law. Parliament don't want to stop people from going to court. It is a basic presumption that parliament would never want people to stop going from want people to stop coming to court with their concerns. All right. So these are a few presumptions that are followed in general while you are applying any statute. Now, let's discuss a very small topic. It basically is kind of an other law, that is Sharia law. The nature of Sharia law, it is usually a Islamic legacy system. Islamic legal system. It is believed to be given by Allah, and it is used in countries like Saudi Arabia, UAE, Kuwait, and Pakistan. So, this kind of law is used by majorly Islamic countries. It is a law given by Allah. The sources of this law, the sources of Sharia, is of course Quran, a primary source, a divine revelation. Sunnah, accepted practices, sayings by prophet, etc. Sunnah is where these are accepted practices said by prophet. Madhab, the juristic schools of thoughts, mainly Sunni and Shiti. All right. And then constitution, domestic constitutional rules may also influence application. So Sharia law is dependent on all of these, that is Quran, Sunnah, Madhab, and constitution. It is a combination of all of these wherein a law comes into picture or a law is made. These are the sources of making law. What are the roles of judges? Judges are mostly clerics through some states allow some states allow secular clerics as well. Their job is to apply the law and not to make it. All right, so they are supposed to apply the law and not to make a law, because whatever is written in the Quran, it is supposed to be applied just that way. They are just supposed to interpret it or to apply it. They are not supposed to make new laws. Interpretation powers is still limited since the law is considered to be as divine. So even if you're interpreting it, your powers are very, very limited because the law is divine. You're just supposed to apply it and you're not supposed to make new laws. The Quran lacks clarity and judges turns to Sunnah for explanation. Basically, many a times Quran might lack clarity and the prophets, that is Sunnah, accepted sayings or practices by prophets. So people turn to prophets to explain the law. If Quran does not addresses an issue, Sunnah may provide guidance over it. So basically, when we are talking about judges, you can in simple language say that prophets are judges and they apply law, they interpret it even if they have limitation. However, they cannot make a new law. Just in case if anything is not addressed in Quran, then they can come into picture and they can provide guidance, but they cannot make law. I hope this is clear. Sharia law is clear to you guys, and statutory of interpretation is also clear. Again, statutory of interpretation is a very important, you can say, kind of a topic for your examinations. All right, that's it for today. Well, that completes part A of chapter 1. If you have followed all the lectures, you now have the core of legal framework that every other topics builds on. Next, we shift into the parts of the syllabus where exam style questions start becoming predictable. Stay with the series because the real scoring begins from the next lecture, and the MCQ shorts plus full length solution will make revision effortless. Thank you so much for your time. See you in the next lecture.